So I'm Ann Herzberg, I'm the legal advisor of NGO Monitor. We're a Jerusalem-based organization. We monitor the activities of human rights groups and humanitarian NGOs that operate in the Arab-Israeli conflict. At the conference so far, we've been hearing a lot of examples of modern-day anti-Semitism. And I'll just go over a few incidents that have happened over the past year or so. In the UK, Israeli officials are wary of traveling there for fear of being arrested as war criminals. In May, the second highest Israeli diplomat in the UK was attacked by Palestinian protesters, leaving a speech in Manchester. Also, just in June, a judge in the UK actually acquitted a group of vandals who had attacked a factory on the basis of supporting Israel. So basically they invoked that Israel made me do a defense, and the judge let them off in that case. In Sweden, one of the largest newspapers last year printed an article that basically reviving the medieval blood libel that Israelis were harvesting Palestinian organs for profit. Here in the US, Michael Oren, the Israeli ambassador, has been heckled at speeches, Brandeis University. There was a challenge of him speaking there as giving the commencement address. Many universities are contemplating divestment from Israeli corporations. And in Canada, there have been a lot of attacks on synagogues, and Israeli apartheid events are flourishing. Now, one might think that these events are the work of Muslim extremists, or Holocaust deniers, or other far left-wing radicals. But unfortunately, a very often overlooked aspect of these events is the role of human rights and humanitarian aid organizations in these campaigns. And more disturbingly, many of these campaigns are actually being funded by the European Union, many European governments, large humanitarian Christian organizations such as Christian Aid in the UK, Trogra in Ireland, and Diakonia in Sweden. And also, several prominent foundations are providing the funding for these campaigns, such as the Ford Foundation, George Soros' Open Society Institute, Oxfam Novib of the Netherlands, and even, very surprisingly, the New Israel Fund. So while NGOs have been engaged in these campaigns for a long time, at the UN 2001 World Conference Against Racism in Durban, South Africa, there marked a major escalation in this type of campaigning and strategies. So at the conference, 1,500 officials from NGOs gathered and accused Israel of perpetrating Holocausts, ethnic cleansing, new kind of apartheid, crimes against humanity, and genocide. They revived the Zionism is racism slogan, and activists marched in mass protests, declaring what we have done to apartheid in South Africa must be done to Zionism in Palestine. Jewish participants were intimidated and excluded from meetings. These racist and anti-Semitic attacks were not limited to Palestinian groups, but international NGO superpowers such as Amnesty International and Human Rights Watch played a major role in creating the hostile atmosphere there. So up here on the slide, I have a few excerpts from the NGO declaration from the Durban conference. And that final declaration basically established what we call the Durban strategy, a policy of complete and total isolation of Israel as an apartheid state, and calling for the imposition of mandatory and comprehensive sanctions and embargoes and the full cessation of all links between all states and Israel. Now, the Durban strategy has become the cornerstone of the global anti-Israel boycott, divestment, and sanction, or BDS movement. So here are just a few images from the various BDS campaigns. We have the Blood Orange campaign that was put out by Oxfam Belgium in 2004. It sparked a lot of controversy. They eventually did rescind that poster. At the bottom, this is a photo from a protest in Brussels just a couple months ago, where several EU grantees and actually New Israel Fund grantees participated in a divestment protest and were actually drinking blood symbolically to symbolize Israelis drinking the blood of Palestinians. And in the UK, we see the movements for academic boycotts, church divestment campaigns, the union boycotts, and then also we have a lot of major international aid organizations like TROCRA, Diaconia, Amnesty International, campaigning for arms embargoes against Israel. They've been very involved in trying to downgrade EU-Israel relations, most notably campaigning against the EU-Israeli Association Agreement, and also they've tried to block Israel from entering the OECD. So these are just a few examples of the BDS movement. Another category of campaigns that grew out of the Durban conference is what I call NGO Lawfare. So there's approximately 5 or 6 NGOs that have been responsible for the cases against Israelis around the world in universal jurisdiction lawsuits. So we have, for instance, in the UK, there have been several initiated by the Palestinian Center for Human Rights against Durban al-Mug. Also in Spain, we have a case against 7 Israeli officials. That also involved the NIF and EU-funded NGO Adela. We have Al-Haq and Al-Mazan that are also European funded. Tried to have Yehud Barak arrested at the end of September in the UK. And also there was a case against, an arrest warrant issued against Sibi Livni in London in December 2009. We're not quite sure which NGOs were involved with that. Hamas actually has its own war crimes NGO called Tafek. And they claimed responsibility for that case, but it's unclear if some of these other organizations that are usually behind these cases were also involved. And of course, since the Gaza war, NGOs have played a major role in lobbying the International Criminal Court and the prosecutor there to take up the case of Israel. And some of the NGOs involved in that lobbying effort include Human Rights Watch, Amnesty, Al-Haq, PCHR, Adela, the Public Committee Against Torture in Israel, and the Federation for Human Rights in France. The Goldstone process was probably the major manifestation of the Durban strategy over the past few years. NGOs were very active from the beginning of the Goldstone process. They actively lobbied the Human Rights Council to set up the Goldstone mission. NGOs were involved. Goldstone held a town hall in Geneva where he got testimony from NGOs. Amnesty International circulated an outline, a proposed outline for his report, which he subsequently adopted. They also provided him with a list of 36 incidents that Goldstone claims he investigated in his report. Over 500 NGO claims and submissions were incorporated into Goldstone's report, often repeating unverifiable and false claims that Israel is deliberately attacking Palestinian civilians. And since the Goldstone report's come out, NGOs have been largely responsible for the campaign to lobby for the report. And I find that to be basically an act of self-promotion on behalf of these organizations, since their claims are incorporated into the report. By then lobbying, if the report was not accepted, it would be casting doubt on the credibility of their own claims. So basically this lobbying amounts to self-promotion. So basically, NGOs invest millions of dollars every year into publications, public relations blitzes, and lobbying efforts, utilizing the rhetoric of human rights and international law to single out Israel as the violator and abuser of international law and human rights. And by couching these political attacks in legal terms, NGOs seek to create a veneer of credibility and expertise, thereby increasing international pressure against Israel. And since the 2001 Durban conference, we've seen this process play out on many occasions. We have Jenin in 2002, the ICJ case against the security barrier in 2004, the Lebanon War in 2006, of course the Gaza War in early 2009, and just this past year with the flotilla. The process is usually the same. Israel is faced with a spate of terror attacks, and responds with increasing severity. NGOs then issue countless condemnations, mostly against Israel, making accusations of war crimes, crimes against humanity, and the intentional targeting of civilians, based on speculation or little to no hard evidence. The media and the international community adopt these claims at face value, and rarely engage in independent verification, what we deem as the halo effect. If you claim you're acting in the objective of human rights, people will automatically give credibility to your claims. So whereas journalists will not necessarily take a government's claims at face value, oftentimes they will merely just repeat an NGO's claim because that NGO claims that they're advancing human rights. At the UN, and as we heard from ISGAP, particularly at the Human Rights Council, NGOs engage in further condemnations, and the UN then calls for international investigations of war crimes trials, and NGOs are then called upon to play an integral role in those processes as well, further entrenching their influence and claims. The context of terror is completely erased, as are Israel's rights to self-defense and self-determination. Virulent anti-Semitism from Iran, Hamas, and Hezbollah are completely ignored. And we've documented on our website countless examples of this activity. So I'm going to highlight a few now of some of the most egregious, but there's on our website hundreds, if not thousands, of examples. I also have a copy of some of our reports in the back that you're also welcome to take. So according to these NGOs, Israeli apartheid, colonialism, and occupation are rooted in the concepts of Zionism and a Jewish state per se. So they are not based on specific policies or territorial disputes, specific policies of the Israeli government or territorial disputes. And as such, the Durban strategy matches several working definitions of anti-Semitism. So here we have the EU Working Group for Anti-Semitism, and it was also subsequently adopted by the UK Parliamentary Committee on Anti-Semitism. And it's the denying the Jewish people their right to self-determination, e.g. by claiming that Israel is a racist state, is a racist endeavor, is an example of anti-Semitism. Alan Dershowitz came up in a lengthy article with several criteria of what he would deem to be anti-Semitic activity as opposed to just criticizing Israeli policies. And Earl Kotler, who's here, has noted that a new globalized virulent anti-Semitism denies the Jewish people the right to live as equal members of the family of nations. And I also highly recommend the new book, Trials of the Diaspora, from Anthony Julius, where he also documents several anti-Semitic canards that have been adopted by the anti-Zionists and the NGO movement. So now I'm just going to go through a few themes that NGOs use in their reporting. So the first one is that Israel is an apartheid state. And again, we have a quote from Erwin. That the indictment of Israel as an apartheid state also involves calling for the dismantling of Israel. So even though Israel is in no way comparable to the apartheid regime in South Africa, and based on a lot of the definitions utilized by NGOs to define apartheid, pretty much every country in the world would be guilty of apartheid. Most of these NGOs are only campaigning against supposed Israeli violations. And also these organizations ignore what could be said to be gender apartheid or religious apartheid in countries like Saudi Arabia. Another theme is the Judaization, or the Zionism is racism theme. The Judaization claim is very interesting. It's actually terminology adopted by the PA. The PLO has a website called the Negotiation Support Unit, Negotiation Affairs Department. And on that website, they have many policy briefs on several topics. And one of them is Judaization. And it's quite interesting when you go through these policy briefs, a lot of the arguments laid out in those papers are actually then echoed in the NGO community. And so one of them is Judaization. So you have a group here, Iramim, that's funded by Europe, and also the New Israel Fund is utilizing this term about East Jerusalem. But it should be noted that it's not just about East Jerusalem or the West Bank, but many NGOs also use this term to refer to neighborhoods in Yaffo, Akko, and the Negev. So in essence, these groups are also challenging the legitimacy of a Jewish state within the Green Line as well. And it's basically painting Jews and Israelis as foreign and colonial occupiers who have no historical ties to the land. Another theme that they've adopted is basically reviving the discredited Zionism as racism canard. So basically, under this theme, Palestinian self-determination is considered an international legal obligation, whereas Jewish self-determination is considered racist and illegitimate. The law of return is deemed racist. Jewish symbols such as the Magen David on the flag or the Hatikva are also deemed to be racist. And although most countries in the world, and in particular in Europe and also amongst Muslim countries, there are official state religions, there are religious symbols on the flags, Israel again is the only country where this is being deemed as racist, where this is being used as a standard for why the state itself is illegitimate. And in addition, a lot of NGOs are campaigning and trying to transform a political and territorial dispute into one of race. So groups like Amnesty International, when they put out condemnations against the security barrier or checkpoints, oftentimes will say Israel has imposed a system of checkpoints in order to discriminate against the Palestinians because they are Palestinians, totally erasing the context of terror and removing that aspect. This is an NGO Badil that's funded by some European countries. They advocate for the right of return, and they sponsored a contest called the Right of Return Caricature Competition, and this is one of the examples of that contest. And you can look on their website, they have a couple hundred entries. But again, this is the type of thing that is being produced with European taxpayer money. Another theme that is quite prevalent, unfortunately, in NGO campaigning is Holocaust and Nazi rhetoric. So we have Mada El Carmel and Adela, which are Arab-Israeli NGOs and are funded by the New Israel Fund as well as Europe. Put out a document in 2007 called the Haifa Declaration, which basically called for the dismantling of Israel as a Jewish state. And at the end of the document, they note that the Holocaust should not be used to belittle the universal human and moral lessons to be learned from this catastrophic event. It should not be used by the Jews to establish their state. So again, European and Jewish money is being used to fund these types of activities. Alternative Information Center often invokes this type of rhetoric in their publications. Amnesty International also in 2007 put out a report on the security barrier, and they deemed it the wall of death, which is harkening back to Auschwitz. Other types of imagery and rhetoric, NGOs frequently refer to Palestinians being held in ghettos, ethnic cleansing. During the Gaza War, a group of Israeli NGOs claimed that Palestinians were being held in pits, that Gaza is one big concentration camp or one big prison. Their publications often use Nazi imagery such as barbed wire or images of a Palestinian child holding his hand up being shot at by the IDF. One very troubling example from the Goldstone report, Desmond Travers was a Goldstone mission member and has since engaged in quite a number of far radical anti-Israel campaigning, including testifying to the Russell Tribunal, which took place in Barcelona and attempted to put Israel and its allies on trial, basically eliciting anti-Semitic testimony from an NGO representative at the public hearings Goldstone held in Gaza. So for instance, he asked this question, and just to let you know, the witnesses that appeared in the public hearings for Goldstone were all pre-vetted in advance. So the mission members knew what people were going to say, and they specifically chose that because they wanted to make the messages public, and Goldstone himself has acknowledged that. So here we have Desmond Travers saying that Israel used seemingly militarily unnecessary violence, actions that are very, very strange and very unique. Now, of course, anyone familiar with warfare knows that these types of actions are, if they happen, are not strange or unique. They happen in almost every conflict. And he's asking these NGO representatives what mindset or what conditioning or what training could bring around a state of behavior that would cause a soldier to shoot children in front of their parents. So in response, the two members of the Gaza Community Mental Health Programs that are also European funded responded that the Israeli soldier has the image of absolute superiority, that they don't think of humanity at all, and that there's an identification with the aggressor, the Nazis. So this is on the public record of the Goldstone hearings. It's on the UN website. And if you'll note in the Goldstone report, it's quite interesting. They actually used brackets on a lot of this testimony to take out the more offending language. So like sometimes when these two representatives were referring to Jews, they would put Israelis in brackets. So it's quite interesting when you take a look at that. And again, the testimony is available online, and you can also look at it in the report. Another theme are adoption of religious themes. So overt references to the canards of deicide. So here, this is a British NGO called War on Want, also again European and British government funded. They put out a series of Christmas cards every year. So here we have Joseph and pregnant Mary being searched at the security barrier on the way to Bethlehem. And many Christian NGOs also have sold nativity scenes which have the security barrier running through it. I'm just running out of time, so I'll just quickly go through this. Christian Aid did the Child of Bethlehem campaign. Of course, we have modern-day blood libel accusations deliberately targeting Palestinian civilians. Here's a look at the massive funding that's going into these types of campaigns. As you can see, Oxfam, its budget rivals that of large corporations. In contrast, the Israeli Hasbara budget is about $10 million. So you can see what the Israeli government and the Jewish community in general is up against. Ken Roth frequently invokes this type of libel. He'll claim the NATO and Afghanistan and Pakistan stress the importance of protecting civilians, whereas Israel wants to pummel civilians. And of course, we know that's not true. The U.S. record in Afghanistan in terms of harming civilians is much worse, actually, than Israel's record is. Again, putting forth quotes to ascribe racism to Tzipi Livni. Here's just a list of massive funding being poured into these NGOs by the EU. And this is a chart available on our website just showing also the many countries that are giving money to these organizations. As you can see, there's a lot of repeat donors. Again, we have here some more examples of demonization. The deal, again, organizing a targeted campaign to expose the Jewish community, Jewish and Zionist community's double standards, and expose the lies of the AIPAC and the Anti-Defamation League. Palestinian Center for Human Rights hosted a conference in Cairo entitled Impunity in the Prosecution of Israeli War Criminals. As you can see on the poster at the bottom, they're thanking the European Union and Oxfam for funding the conference. NIF, unfortunately, is also pouring lots of money into these same organizations. We issued a set of guidelines that we thought the NIF should follow to stop these practices. And actually this week in the Jerusalem Post, there was an article that they may actually be considering doing something about this. For a long time, they denied they were doing it. Now they're starting to realize that there's a problem. This was a poster put out by a group of NIF grantees for this conference, My Land, Space, Body, and Sexuality, which shows an Israeli soldier groping a Palestinian woman. So again, the best thing we can do is to name and shame the funders of these campaigns and to point out the destructive impact. We've had a few successes. Also, Human Rights Watch, unfortunately Michelle's not here, but she used to work for Human Rights Watch. Human Rights Watch, they've had a lot of scandals in the past year that are finally getting out in the press. There's been some massive changes in NGO funding. Canada's cut over $11 million of funding to these groups. Schroeder in Ireland, they've had their funding cut. NIF guidelines. And so hopefully we can begin to make an impact. So thanks very much.
When we have all the speakers, because we're really pressed on time. So we don't have a chair. Taking the front. All right, we'll try to be brief. I'm going to talk about, I entitled this talk, this is a paper I've been working on for a month or two now. I entitled this talk the Metastasizing of Lawfare. I'm interested in a couple of different phenomena here. In particular, what I'm interested in is the spread, the lawfare phenomenon that we're all kind of familiar with now, the way it's spreading out from its core area being indictments for war crimes and crimes against humanity, against public officials, into various other branches of law, sometimes surprising branches of law. Here it surprised me because I've got two cases that are kind of tax and import duties, customs cases, that are part now, I think, of the lawfare family of cases that show an interesting development in the field. One's called Britta against the Hamburg Customs Office. It's a case I want to talk about for a few minutes, from the European Court of Justice. And the other one is a case from a few years ago, Canadian Magen David against the Minister of National Revenue. It's a case from the Federal Court of Canada. Two cases, both do similar things. That is, both are attacks on Israeli jurisdiction over goods and services coming from occupied territories. Both are cases that are in the context of tariffs and tax law. Both are cases that the holdings are against the Israeli interests. The holdings are against Israel, where precedent in each jurisdiction had gone the opposite way regarding far less friendly countries. That is to say, in Europe, there was a direct precedent against this case that held in favor of Morocco. And in Canada, there is a direct precedent against this case, not direct, a precedent against this case that held in favor of Iran. These are both cases where a domestic court defers to an analysis of international law and then turns international law on its head. And then, most interestingly, I find, both are cases that are very antagonistic to Israel and any Israeli interests from friendly jurisdictions. That is, the first case is from Germany, and the second place is from Canada. These are two countries the foreign policy establishments of which are quite friendly to Israel. So we've got a phenomenon of the legal system and courts taking a completely different attitude towards Israel and the Middle East conflict, and as it plays out in the judicial system, as the foreign policy establishments in their home countries do. Quickly, Britta Britta is a German company. It sells drink makers and canisters, these things that you put, these gas-powered canisters that you put water in and it turns it into seltzer. These are imported by Britta into Germany. They're made under contract in an industrial complex in Mishur Adumim, which is an industrial park adjacent to Ma'ale Adumim, which is east of East Jerusalem in the West Bank. The case raised the 1995 Israel-European Union Association Agreement, which established a regime for duty-free imports from the State of Israel into the European Community. The treaty's way of establishing the origin of the products is by a certificate of origin being certified by the national authority of the exporting country. So Israel certified Britta's seltzer bottles when they exported them into Europe. The Israel Customs Authority certified them as originating in territory, quote, under Israel Customs Authority. The German Customs Office in Hamburg was skeptical, pressed further, and asked whether the goods were produced in the West Bank, Gaza, East Jerusalem, or the Golan Heights, in a specific question directed to the Israel Customs Authorities. That inquiry went unanswered, for whatever reason, discretion being the better part of valor or something. Germany then imposed full import duties on the products and said the EU-Israel agreement doesn't apply to products, to these particular products. Britta took that decision to court in Germany, which then referred the question of treaty interpretation to the European Court of Justice. The European Court of Justice, as is its practice, requested a legal opinion from the Advocate General, so the EU's Advocate General. This is an office that I wasn't familiar with before I started doing this research, but this is something that exists in civil law countries that in the English common law world I don't think we really have the equivalent, although I've seen it characterized as something close to what the United States considers the Solicitor General. But this is a legal officer that oftentimes will issue opinions that courts then defer to, or courts can incorporate into their judgments as they wish. The Advocate General opined that the Israeli occupation of the West Bank is contrary to international law as expressed by the United Nations, and specifically quoting from the Advocate General's opinion, paragraph 109, he said, quote, "The borders of the State of Israel were defined by the plan for the partition of Palestine, drawn up by the UN Special Committee on Palestine and approved on November 29, 1947 by the General Assembly in Resolution 181. On May 14, 1948, the head of the Provisional Government of the State of Israel proclaimed the birth of that state on the basis of borders which had been defined by the plan for partition of Palestine. Well, anybody who knows their history will know that might be one reading of what happened, but of course my reading is, I think that the only real reading of history is that Ben-Gurion never declared the partition borders to be the borders of the new state. There's this famous little joke, it's not a joke, there's this famous parable between, discussion between Ben-Gurion and Pinchas Rosen, who was Ben-Gurion's friend and advisor, and became the first Minister of Justice of the State of Israel. Rosen was a German-trained lawyer and a kind of a formalist in the old-school German way. Rosen was supposedly admonishing Ben-Gurion that you have to declare the borders, that there isn't a state. Supposedly, he said, in all of Professor Lauterpath's treatise on international law, there isn't a state in the book that doesn't have well-defined borders, that we don't know where the borders are. And supposedly Ben-Gurion, who was not a formalist at all, was a pragmatist, said, wait till the next edition. Anyway, we know that Ben-Gurion didn't declare the partition borders to be the borders. More than that, we know that on May 11, 1949, Israel was in fact admitted to the United Nations with far more territory already than the partition borders would have given it. Anyway, the Advocate General, back to the Britta case, goes on to say that the UN Charter and Germany's commitments under the UN Charter predate, which mean commitments to recognizing only the partition borders, predate and therefore trump the subsequent EU-Israel trade agreement. Right, the EU-Israel trade agreement, which would have given the Israeli Custom Authority the sole discretion, the sole responsibility for determining whether these goods were produced inside Israel or not. The European Court of Justice confirms all of this, and they say in any case the EU has another agreement with the PLO regarding PA-administered territory that they also have to respect. Although, of course, the PA doesn't administer the territories that are still occupied. Right? That is, that under the Advocate General's definition are still occupied. The PA obviously doesn't administer those, or they wouldn't be occupied. In any case, in the end, what the judgment stands for is that the prior treaty, the UN Charter, trumps the subsequent treaty, the EU-Israel Trade Agreement, and therefore, as they say, and the reason is that international law is deeper than the immediate consent of the parties to any given treaty. Now this is, I don't want to go into too much international law theory, but this is a controversial point in the international law world. That is, we have a world of sovereign states, typically. The UN Charter isn't a constitution, it's just one more treaty. It's a big multilateral treaty, but it's just one more treaty in a world of sovereign states that sign treaties all the time. And we usually think that international law is a product of state consent. That is, it's a product of treaty agreements or of customary activities that are consensually done by states. Here, somehow, the ECJ considers the international system as a whole to be greater than the sum of its parts, greater than the treaty commitments that its constituents make from time to time. Now, all of this, as I said earlier, is in the face of a nearly identical case under the EU Kingdom of Morocco Association Agreement of March 2000. The dispute between the EU and Morocco had to do with products originating in the Western Sahara. Now, the Western Sahara, you probably know, is a desert territory on the south, bordering Morocco on the southwest of the Kingdom of Morocco. To make a long story short, it was a Spanish colony. It was called the Spanish Sahara. In 1975, Spain declared its intention to decolonize the area. The International Court of Justice said that the inhabitants have a right to a referendum on self-government. The territory was then claimed by two neighboring states, Mauritania on one side and Morocco on the other. A couple of years later, by the late 70s, Mauritania had dropped its claim, and Morocco occupied the territory of the Western Sahara, sending in hundreds of thousands of civilian settlers and building new towns and industrial infrastructure, etc. And then in a series of resolutions, the United Nations, specifically GA Resolution 3437 of November 21, 1979, early in this piece, said that UN deeply deplores Morocco's occupation of the Western Sahara, calls for the right of the Saharan people to self-determination, etc. Anyway, the Western Sahara is a phosphate-rich territory, and the coast of the Western Sahara are rich fishing waters. The EU-Morocco agreement mirrors the Israeli one, Title II of that agreement calls for a duty-free flow of goods between the two parties. Article 94 says it applies to goods originating within the territory of one of the signing parties, and it gives the Morocco Customs Authority sole authority to determine what goods have originated in Morocco and what haven't. Morocco, as I said, exports fish and phosphates to the EU, qualifying these as duty-free exports to the EU. The European Union has taken the position that the EU-Morocco agreement doesn't specifically exclude the Western Sahara from Moroccan territory, and therefore the Moroccan certificate of origin for goods originating in the Western Sahara can be taken at face value. This, and I should say, this is in spite of a specific opinion given by the legal advisor to the Secretary General to the Security Council in January of 2002, saying that Morocco's exploitation of Western Saharan resources violates international law under the UN's decolonization resolutions and its declaration on non-self-governing territories. The EU's answer has been that domestic law and policy of the EU trump these international instruments. Now, again, that actually shouldn't be all that controversial among international lawyers. That is to say, lots of courts around the world have said that, including U.S. federal courts have said that domestic law will, in the event of a direct conflict, domestic legislation will trump international agreements. But in 2006, the EU-Morocco fisheries agreement specifically allowing fish imports from the Western Sahara was said to trump the EU, was said to trump the Security Council's legal opinion as to the status of the Western Sahara. So here, the EU has ignored international law pronounced by the United Nations in favor of its own domestic policy interests and in favor of, and of course, Morocco's sovereign right to unilaterally determine its own borders. All right, now let's put that aside for a second. Let me spend 5 minutes talking about the case in Canada. This is a case about deregistering a charity. It's another kind of tax-oriented case, tax law-oriented case. Magen David Adom is fully registered as a charity in a lot of different countries, including in Canada, which in Canada, the Canadian Magen David Adom's registration gives, of course, Canadian donors a charitable tax receipt when they donate money. The specific purposes of Canadian Magen David Adom, to quote from the Canada Corporations Act, registration is to donate emergency medical supplies and ambulances directly to the people of Israel. Starting in the late 90s, in 1998, the Canadian Department of Revenue started corresponding in a series of interrogatories with the charity. It started off pointing out that its ambulances are administered by a kind of agency agreement, which it didn't think was a clear enough agency agreement, with Magen David Adom headquarters in Israel itself. The inquiries asked, where are these ambulances deployed? Where does Canadian Magen David Adom's charitable fund get deployed inside of Israel? And it pointed to the website of Magen David Adom at the time, which said that it operates ambulances in, quote, all of Israel, and then included a map of Israel, including the West Bank and Gaza. This is pre-2005 disengagement. The Federal Court of Canada, when the Department of Revenue moved to deregister Canadian Magen David Adom, it went to the Federal Court of Canada. The court quoted, the court recites an opinion letter from legal counsel for the Minister of National Revenue, who said, and I quote, "Israel's permanent control over territories occupied in 1967 is not recognized under international law. This policy is grounded in UN Security Council Resolution 242 and 338 and the Fourth Geneva Convention of August 1949. Consistent with these instruments, it's the Department's view that providing assistance to Israeli settlements in the occupied territories, including assistance in establishing and maintaining physical and social infrastructure, serves to encourage and enhance the permanency of settlements and is therefore contrary to public policy on this issue." The court went all through this and determined that since Canadian Magen David Adom didn't have a clear enough agency agreement with Magen David Adom headquarters to determine where the ambulances, the Canadian-funded ambulances were being deployed, they could assume that they were being deployed everywhere where the Magen David Adom's map said that they operate, and therefore this was contrary to Canadian law. Again, the Department of National Revenue, the Minister of National Revenue at the time, submitted one interpretation of international law. In fact, there's a good argument that this wasn't at all the correct interpretation of international law. We know international lawyers know, the 1971 Namibia case. The International Court of Justice said that while courts are not supposed to recognize permanent changes brought about in occupied territories, there's a so-called humanitarian exception. As the court said, this must not result in depriving the people of those territories of any advantages to be derived from international cooperation. Now, it's easy to see Magen David Adom fitting into the humanitarian exception. Whatever else one thinks about the international legal status of the West Bank, it's easy to see Magen David Adom fitting into the humanitarian exception to the general rule. You know, Amnesty International, finally all of the NGOs, even the ones that NGO Monitor criticizes, have at least, you know, Amnesty International, they've come to the, in its 2003 report on violent same settlers, has come to the conclusion that perhaps they shouldn't be there under international law, but they are human beings with rights. To deprive ambulance services, to deprive these populations the benefit of ambulance services seems precisely the interpretation of the Fourth Geneva Convention that the ICJ was warning against. In any case, the Federal Court of Canada took the Department of Revenue's interpretation of international law and ran with it, and used it to trump the charitable registration of Canadian Magen David Adom under the Income Tax Act. In other words, here, international law, or at least one contentious version of international law, overrides the domestic legislative policy. All of this, I should say, in face of well-established precedent in Canada to the contrary, not in the tax field, this is kind of rare in the tax field, but there's certainly lots of long-standing precedent to the contrary. Canadian courts have long held that where there's a collision between domestic legislative policy and international commitments, it's the domestic legislative policy that trumps. We've had recent, you know, in the past decade, we've had cases in the field of terrorism. Famous case in Canada, the Ahani case, that reiterated the same principle, that Ahani was a terrorist, was an operative of the Iranian government who was found to be a terrorist by the Federal Court of Canada and was declared deportable. He took his case to the UN Human Rights Committee under the optional protocol to the International Covenant on Civil and Political Rights, saying that he would be tortured and mistreated in various ways if he were returned to Iran. The Canadian courts have said that we can ignore the rulings of the UN Human Rights Committee under an international agreement because legislative policy, the Supreme Court of Canada said that the man is deportable. Legislative policy, when there's a direct collision, will trump the international law. All right, European Court of Justice, to sum up, prefers a treaty obligation to its specific trade obligation in the face of precedent to the contrary, and as I said in the process, turns the relevant international law on its head. The Federal Court of Canada prefers the Geneva Convention to its own specific income tax obligation in the face of precedent to the contrary, and in the process turns the relevant international law on its head. Both courts are twisting around here to deny rights to the Israeli interests and entities, where they have not done so with respect to Morocco on one hand and Iran on the other hand. And so my real underlying question is, well, what gives? Why should this be? Now, I'm not going to go into, as I said, the paper involves a fair bit of international law theory, which I won't go into now because I want to save a few minutes for my next panelist, my colleague here. I just want to say that preferring the first treaty over a latter one and preferring international law obligations to statutory ones, which is the message of the Britta and the Magen David Adom case, they both mean the same thing. That is to say, the multilateral commitment would trump the unilateral state policy. Okay? Preferring a second treaty over a prior one and preferring an international treaty to a domestic or legislative policy also amount to the same thing. And these are the messages of the Western Sahara case and the Ahani case, two cases on the other side of this paradigm. They also amount to the same thing, and they amount to saying that the unilaterally formulated state policy trumps the multilateral commitment. All of this in international law theory, both of these are eminently possible in international law theory. Right? That is to say, it could be that state commitments, sovereign state commitments, trump multilateral commitments, or it could be that multilateral commitments trump state commitments. There's a good logical argument either way. It's inherently manipulable in international law, and there's not much of a way out of that paradox. What bothers me, what intrigues me, and what bothers me is that this is all being done in the courts. You know, international law actors traditionally traditionally international law isn't judicially determined. Traditionally, it's only kind of, it's determined in what we usually call the horizontal self-judging system of international law. That is, states, state persons, statesmen, foreign ministers, heads of state, debate these things, take positions in international law fora, and as the debates progress, we see which position trumps the other. To do it in a legal system is in a way to import that explicitly politicized determination into a forum where you think it's not politicized, but this determination of whether or not one trumps the other, a second treaty trumps the first treaty trumps the second, domestic trumps the international, or international trumps the domestic, can't be determined absent politics, and it's much less transparently done in a judicial system than it is in a classic international forum where heads of state or foreign ministers debate these things out. So in a way, not to misuse a legal cliche, but in a way, courts have become the most dangerous branch in this lawfare business, not the least dangerous branch as they're supposed to be in ordinary domestic litigation. Thanks.
I'm talking about Durban 2 and the issue of anti-Semitism in Cosmopolitan global democracy. I'm presenting this paper also on behalf of my colleague, Matthias, who is a promising doctoral student at the University of Vienna, but due to conflicting commitments, he can't be here today. We are both political scientists, and after these two fascinating presentations, I have to admit that we are real ivory tower academics, if you will. The objective of our paper is to discuss anti-Semitism, oftentimes directed against Israel, as a smokescreen for the less accepted onslaught against Jews at the 2009 Durban Meeting Conference in Geneva. In the upcoming 20 or so minutes, let me thus proceed as follows. After a brief description of the events at the Durban Review Conference, which I will henceforth just call Durban 2, which took place in Geneva in April 2009 as a follow-up event to the 2001 Durban World Conference Against Racism, I will pinpoint the core anti-Semitic moment of Durban 2, namely the singling out of Israel. The second part of the lecture will address the transformation of anti-Semitism in what we shall term cosmopolitan global democracy. Finally, I will map out a normative conclusion by arguing that cosmopolitan global democracy is unlikely to become a means to abolish anti-Semitism from events such as Durban 2 or presumably other United Nations settings. Now, at the beginning of my presentation, please allow me to read out two short quotes. The first by UN High Commissioner for Human Rights, Navi Pillay, the second by UN General Secretary Ban Ki-moon. Both were made on 20th of April 2009 at the closing of Durban 2. That is to say, after the scandalized speech by Iranian President Ahmadinejad. According to Pillay, I quote, "The best riposte for this type of event is to reply and correct, not to withdraw and boycott the conference." Ban Ki-moon compliments, quote, "That is what the United Nations is all about. People coming together from all walks of life to engage in dialogue and find common reformed so that all members of our global community can live in peace and dignity. End of quote. What has happened? Canada, the United States, Israel, Australia, New Zealand, Germany, Italy, the Netherlands, and Poland declined from participation at Durban II due to the anti-Israel stances which became obvious during the preparation process. Others, such as the United Kingdom and 22 further European countries, boycotted Ahmadinejad's speech. The Czech Republic, then holding the rotating European Council presidency, withdrew its delegation shortly after the anti-Semitic tirade. Also, Pillai and Ban Ki-moon condemned Ahmadinejad's words in the strongest terms and recalled the UN resolution on the ban of Holocaust denial. But at the same time, they praised the ideas behind the conference and the outcome document as a reaction to Ahmadinejad. Now, we deliberately picked these two statements and not, as one might expect, an extract from the translation of Ahmadinejad's speech. What struck us was the tension between the rejection of the Iranian president's anti-Semitic outburst and the almost simultaneous rebuke against those delegations which either cancelled their participation or left the auditorium during Ahmadinejad's speech. Dialogue, as it seems, precedes principle, whatever ideological price one has to pay in the end. Let me thus clarify the points of departure for our subsequent considerations. The emphasis of our analysis is placed on the context in which Durban II happened, and less so on its key anti-Semitic agitators. As Professor Ruth Wise said yesterday, anti-Semitism is about the strategies of organizing politics against the Jews, and we are very much in line with that. To be sure, we share the moral outrage at Ahmadinejad's hate speech and related, if more modest-sounding, pronouncements. But as political scientists, we seek to understand, and when I say here understand, I mean intellectually understand, and definitely not extending any kind of sympathy. So we seek to understand the specific ideological groundings on which the events of Durban II could unfold. Arguably, normative conclusions regarding Durban II and, more generally, regarding anti-Semitism in cosmopolitan global democracy can only be drawn on the basis of sound theoretical explanations and systematic research of the respective documents. This also reflects our somewhat growing dissatisfaction with the existing academic literature on the Durban conferences, Israel and the United Nations, as well as anti-Semitism in the United Nations. Many of the readings, at least those that we have consulted, are either largely descriptive or highly morally engaged and fail to provide insights into the how and the why of the persistence and transformations of anti-Semitism. Hence, the guiding question of our research reads as follows: which are the characteristics of anti-Semitism in cosmopolitan global democracy, and to which degree do they apply in the case of Durban II? In this lecture, I shall almost exclusively address the first part of the question, while the thorough examination of the Durban documents is still ahead of us. Now, as we talk of anti-Semitism at the Second Durban Conference, it is due to establish what we estimate to be the core anti-Semitic moment of this event. A hermeneutical reading of all relevant documents made clear that the continuous singling out of Israel has to be termed anti-Semitic. Israel does not only define itself as a Jewish and democratic state, it is also perceived as a Jewish state from outside, not least by its most fervent enemies. Certainly, attacks against individual Jewish activists present in Geneva, be they Israeli or not, should not be downplayed. However, it is safe to say that the overarching theme of the Durban II anti-Semitism was the attempt to exclude Israel from the international community. By way of historical analogy, this recalls the processes of marginalization, exclusion, deportation, and physical extermination of Jews from various forms of Gemeinschaft, and I deliberately use the German term here, be it religiously, nationally, or racially defined. Israel, according to its foes at Durban II and elsewhere, allegedly stuck to a retarded version of nationalistic particularism and shamelessly claimed the status of being an eternal victim of the Holocaust. Now, on a footnote, our analysis is not concerned with any scrutiny of Israeli government policies and military action. We neither survey the location of settlements, nor will we count up death tolls of Israeli and Palestinian civilians. We primarily focus on understanding the circumstances under which Israel is being turned into the Jew among the nations. Making this crucial distinction more explicit, we, for instance, do not buy into endless arguments on whether Zionism could have racist elements. What we consider as anti-Semitic is the fact that Israel's national ideology was branded racist by the United Nations, whilst numerous others, or the general nexus of ethnically defined nationalism and racism, never were. The singling out of Israel, and theoretically, but not in reality of any other country, can occur in various international politics settings. What upends the peculiarities of Durban II? In pursuit of our objective to provide a more analytical account of anti-Semitism at Durban II, we will first have to introduce the concept of cosmopolitan global democracy. In the aftermath of the end of the Cold War, and further driven by the phenomenon of globalization, a considerable body of scholarship on cosmopolitan global democracy emerged. Now, the main thinkers we draw on here are Archibucci and Held with their seminal 1995 volume entitled Cosmopolitan Democracy, an Agenda for a New World Order. Archibucci and Held thus envisage a political program which promotes the democratization of international politics, not merely in terms of democratic decision-making in interstate relations and international organizations, but also for the involvement of the people, for instance, in an elected world parliament. Strikingly, Archibucci chiefly dwells on questions of procedural democracy while being rather silent on substantive aspects such as concrete norms. Falk, who is another author who publishes together with Archibucci and Held, complements this vision but with his emphasis on civil society participation. In his 2008 follow-up monograph, Archibucci assigns particular significance to the United Nations. And he adds the element of juridification to the previous one of democratization. The upgrading of the International Criminal Court by the implementation of the right to individual appeal should guarantee the enforcement of cosmopolitan law. That is to say, rights every human being is entitled to. No less important, however, are the voices that are critical of Archibucci. As Hawthorne argues, in an upshot, cosmopolitan global democracy remains an elitist endeavor of limited practicality. Dahl Urbinati more generally questioned of the democratic majorities. Beside Archibucci, Heldenthal, Habermas and Wolff, now the more European debate, proposed almost mutually exclusive concepts of cosmopolitan global democracy, whilst Habermas clearly favors Western, or at times European, liberal democracy as the only viable model to build on globally. Wolff calls presumed Western hegemony at the UN in question and encourages even the formation of counter-hegemonic strategies. This is very much imbued by the significance attributed to political controversy inside the UN. Habermas suggests that an intersubjective reason would reconcile differences and dissolve antagonisms. Wolff places difference and antagonism right at the center of her approach and argues that the aim of the democratic politics should be to tame this antagonism, to transform it into agonism by producing opposing political projects citizens can identify with. So that's all the theory I'm going to present here. Now, based on this brief discussion of cosmopolitan global democracy, the main characteristics of anti-Semitism in respective settings will be sketched out here. Being aware of the risk of all too sweeping generalizations, it can be maintained that Western, and especially European post-Holocaust anti-Semitism, became marginalized and ostracized thanks to a mainstream consensus against overt anti-Semitism. The downside of this is, of course, that anti-Semitism is being expressed more latently now. Moreover, non-Jews tend to solemnly identify with Jewish victimhood while simultaneously neglecting Jewish claims for nationhood. By contrast, in cosmopolitan global democracy, anti-Semitism is expressed both noisily and unscrupulously. We here discern the indiscriminate access and inclusiveness toward potentially anti-Semitic agitators, as well as the global stage the latter are provided with. In spite of all criticism, UN settings continue to ground moral high ground. The dearth of normative consensus, be it founded in law or extra-legally, renders anti-Semitism and also the Holocaust subject to deliberation and competitive claims as any other random subject of global concern. Far from promoting absolute truth, we just want to highlight the risk of contestability. Additional features of our definition concern the open hijacking of the Jewish victimhood experience. This has been broadly elaborated by Levy and Schneider, and tendencies that could be summarized as free riding on elements of European or partly Western post-Holocaust norms, such as the ban on Holocaust denial, Nazi prohibition acts, anti-discrimination provisions. The quest of the Organization of Islamic Conference to extend a similar legal protection to Islam as to what anti-Semitism would call, what anti-Semites would call Holocaust religion, is but one highly illustrating example. Against this backdrop, real or alleged Jewish insistence on national particularism is doomed to be backwardly and obstructively anti-cosmopolitan in the eyes of Jew haters. Furthermore, and I'm coming to the conclusion in a minute, we want to pose the question whether modified forms of cosmopolitan global democracy yield the potential to help overcome anti-Semitism. This would imply the adoption of a more legal, or Habermasian, if you want so, cosmopolitanism, which presupposes some level of democracy in domestic politics and a strong national public sphere. Likewise, the above indicated role of a global judiciary gains significance in this context. One can add the normative consensus with regards to the unequivocal rejection of anti-Semitism, not only against individual Jews, but against Israel as a Jewish state, has to be shaped and implemented beyond legislation and adjudication. These propositions are of course reminiscent of the post-war development of European integration. Not only the European Declaration on Human Rights and the European Declaration on Human Rights and the European Court on Human Rights are to be mentioned, but more recently, and specifically also the level of government consensus, which has been reached with respect to the fight against anti-Semitism and Holocaust remembrance. It is quite telling that some count the coming to terms with one's country's dictatorial and especially fascist and/or collaborationist World War II past as a soft accession criterion to the EU. See the respective debates in Croatia and Romania. But, and that's my caveat, precipitate enthusiasm regarding the transferability of the European model to the level of cosmopolitan global democracy has to be curbed. Any binding or at least obliging consensus in anti-Semitism and Holocaust denial is out of sight. Indeed, the General Assembly has passed resolutions on Holocaust remembrance and Holocaust denial, but their global outreach and effect on realpolitik seem to be limited, to say the very least. We have heard Professor Reich's presentation on that today. A somewhat different approach asks for normative thresholds of participation at events like Durban 2. This, however, is not only not feasible, given the design of the UN as an all-encompassing organization, but it would also fail to address the scourge of anti-Semitism. Showing the door to anti-Semitic delegations, as has happened to individual participants at Durban 2, does not prevent anti-Semitism. Our doubts are also nurtured by the very European experience, where government and elite consensus regarding anti-Semitism and Holocaust denial does not necessarily permeate to the public at large. Even the rereading of the Kantian cosmopolitan principle of hospitality, which requires the exactness of otherness, appears problematic in the case at stake. Put differently, does it imply the acceptance of Jewish national particularism, or of any other national particularism, or does the acceptance of this Kantian principle maybe prompt claims by Ahmadinejad and his ilk that their divergent interpretations of the Holocaust have to be accepted as an opinion among many other diverging opinions. Now, to very briefly sum up, what I try to do in this lecture is to present our model of anti-Semitism in cosmopolitan global democracy. The second part, the actual application of our definition on the documents, is, as I've said, still ahead of us in our research effort. And a short normative conclusion that we would like to draw already at this stage of our endeavor is that we have doubts whether global cosmopolitan democracy yields the response to anti-Semitism at the United Nations or in other international politics settings. We conclude that it will remain part of the problem and not become part of the solution, that is to say, the eradication of anti-Semitism. Thank you for your attention.
First I have a comment and then I have a question. My comment to Elisabeth is the most thoughtful, intellectual analysis of the problem that I have heard yet in the two days I've been here. So thank you very much, and I would like to get a copy of your paper as soon as possible. My question is regards NGOs, in particular Amnesty International and Human Rights Watch. There is no doubt in my mind, as we know, Human Rights Watch was founded by a Jew. It is being run today by another Jew. And there's no doubt that if not 100% of the funding, then probably 80 to 90% of the funding is coming from Jews.
Maybe not that high, but yeah.
Although now it may be coming from Saudi Arabia, because we know Ken Ross went to Saudi Arabia to elicit funding for HRW. I'm not familiar with Amnesty International in terms of how the funding here comes about. So my question basically is, why haven't we done a better job of publicizing the anti-Semitic nature of these NGOs so that gullible Jews all around the world who are only too happy to give money to something that sounds decent and turns out to be so vile does not happen?
Well, just to briefly address the funding of Amnesty International, they are not very transparent actually in their financing. And so we understand that they do get some government donations, but in terms of private individuals, we're not quite sure where they're getting their money from. Whereas Human Rights Watch is, puts out their annual reports every year, and you can see who all the donors are. I think people are starting to take note of the activities of these organizations and that they may be anti-Semitic in nature. Barbara Bernstein last year in the New York Times, in his op-ed, came out against his own organization that he founded. It was a very painful moment for him. Also in the work that our organization has done, we've only been around about 7 or 8 years. So we've been trying also to highlight the activities of these groups. I think one problem is, and it will come up a lot, is when you make accusations of anti-Semitism, people are immediately turned off and tend to close off from what you're saying. So I think a lot of, in our work and a lot of work that other groups are doing, they tend to overtly, even though I think in the images and the words that I've showed you, I think there are definite anti-Semitic aspects, elements to what these people and organizations are saying. But I do think in order for the message to be more effective, people don't stress that as much. And it is a problem. But in general, we do find a lot of people, let's say on the center left or on the left, that you may want to try to convince and show that what these groups are doing is immoral and anti-Semitic. They will tend to close off if you say, "Oh, this is anti-Semitic," if you say it overtly. So it's a challenge. How the best.
Wouldn't that basically defy Ruth Weiss's point? It's time to take it on frontally and not be so dicey, walking on eggshells about that it might insult somebody if we tell it the way it is?
Yeah, I agree with you. I think we definitely should put it out there. I definitely think that is the case. But again, we do encounter those problems in terms of the work we do, especially when we speak with government officials. The immediate, I actually was in Ireland speaking to the Parliament in June, and a lot of the parliamentarians, when I was making my remarks, each of them were saying, "We're not anti-Semitic, this isn't about anti-Semitism." They can't really hear what you're saying when you invoke that terminology. I think with Jewish groups, you may have Jewish donors, you may have a better chance of getting the message through.
I'm really focused on that because they tend to be the greatest contributor, the largest percentage contribution to NGOs come from the Jewish community in the United States.
I mean, I think when we, in the past 6 months or so, we've been, highlighting some of the activities of the New Israel Fund and showing where some of the work they're funding is explicitly anti-Semitic, and they came back at us hard. They were putting ads in the paper saying we were right-wing extremists. We're only doing this because we want to prop up a settlement regime. Explicitly denying the claims, even though it's plain for everyone to see on the websites and publications of these groups. So after that campaign, the board of the NIF met at the end of June, and it now appears that they are actually taking what we said seriously. So we do see some impact on that, especially with the Jewish donors, because a lot of times many donors of the New Israel Fund didn't know what was going on. When we were speaking with people and we would show these examples, they had no idea what they were funding. The NIF bills itself as promoting pluralism, progressive causes, and they do fund a lot of positive work in Israel, but they are also funding 20 or so organizations that are involved in anti-Semitic demonization and delegitimization. But I do think depending on the context, that does need to be highlighted.
Ed, what principle can we derive from these cases other than that laws being distorted in ways that disfavor Israel? And even if that is the lesson, is there now an emerging principle of Canadian or German law that anyone whose interests converge with Israel must lose their case? And is that sort of generalizable?
No, I don't. One hopes not. I certainly don't think. No, I don't draw that conclusion. But I do draw the conclusion that it's not easy to draw any legal principles out of the domestic incorporation of these international law cases, because international law itself has this malleability that we can't get away from. But I don't want to. I certainly don't want to I don't want to be paranoid about it. And I don't. Obviously, I'm a Canadian law professor. I know more about Canada than I do about Germany. But I'm not going to say that this is endemic through the Canadian legal system. Here's sporadic examples of what's going on when Lawfare, as we call it, spreads out into unpredictable areas. And so you get the Department of National Revenue in Canada, or the Advocate General in Germany, legal thinkers who know nothing about the Middle East conflict per se, coming up with opinions that courts now defer to. Having said that, I can tell you just last week the Quebec Court of Appeal dismissed a case also involving the West Bank. There was a case brought, the Billion Village, a case by West Bank Village, who claims that some of the village lands have been expropriated by the Israeli government for building a Jewish settlement adjacent to the village. The construction was done under contract to a Canadian company, a Montreal-based construction company. So they sued the Montreal-based construction company in the Quebec courts. It was dismissed it was dismissed on a motion by the Quebec Superior Court. Just last week, that dismissal was upheld by the Quebec Court of Appeal on jurisdictional grounds. That is to say, on the theory that there's no real and substantial connection between what's going on over there. Whatever you say is going on, whatever wrongdoing is alleged, the wrongdoing isn't in Canada, isn't in Quebec. It's in a foreign country, and so therefore there's no territorial nexus to Quebec jurisdiction. So I can't say that Israel or Israeli-oriented interests are losing every case, even in the Canadian courts. All I can say is that we oftentimes now see the lawfare phenomena taking hold of judicial actors and people, the judiciary and other legal officials opining on things that are way outside of their league, and reading, they're kind of, maybe they're breathing in the Goldstone atmosphere. They're reading sources that aren't real sources, that are trumped up sources oftentimes. But like I said, not all the time, because sometimes they read the bona fide legal history.
I would just add to that, also in the UK, actually the same NGO that brought the Canada case, Al-Haq, also brought 2 cases in the UK, civil cases, to impose basically trade sanctions and have the ICJ opinion on the security barrier judicially enforced in the UK. And the courts have rejected that there. So it's not across the board. And also in the US, civil cases, similar civil cases have all been dismissed. So it's actually fairly rare that these cases are enforced, which is good news. Most of the courts, are not engaging in that kind of overreaching, let's say.
Yes, I'm sorry, I missed your presentation, but on a lower level, I go to the Frankfurt Book Fair. For the last 3 years, I've had an agreement with the director of the book fair to get hate out of the fair, because that violates the contract of the displaying publishers. I go around, I take the offending books, many of which, for example, are Iranian incitement to jihad for children. I place them under the name of the publisher, take a photo, and then that evening send them to the director of the book fair. That night the police come in, they confiscate. Following morning I go back and I find the books there, though they've been confiscated. Why? Because when I ask the storekeeper if the police were not there, he opens up the bag and got plenty more. However, please hold these for investigation. Book fair lasts 5 days. 2 weeks later, they come up with some type of reading that it's too late to do anything about it anyway. So it's a nice exercise. But I don't know what legal mechanism there may be to, after the book fair, be able to proceed. You mentioned Germany, and I don't know if any of you have the right contacts to see that it doesn't get stuck just with the police, doesn't simply die. We had one big success, and that was with the Turks, because every year the book fair is dedicated to a country or region, and 2 years ago it was Turkey.
Right.
And I found the most offensive books on the Turkish University of Culture. So the following year, when it was China last year, it was totally clean. There was nothing on any Turkish stand, not for Jews, not against Jews. And when I asked the chairman of the Turkish Publishers Association what happened, again, it wasn't the law that prevailed. He said, well, there was this Jewish organization that sent the Germans to us, and we had these little metal barcodes, and they wouldn't give us barcodes with anything that had a Star of David on it. So, but I would prefer to have a different way.
Yeah, no, listen, my piece is a comparative law piece, and I was comparing Canada to Germany, but I'm a Canadian, not a German. I did have a research assistant who was an intern in a German law firm. So, frankly, if you emailed me the question, I would actually, I'd send it on and try to get an answer. It's a good, it's an excellent question. Oftentimes, legal remedies are too protracted. I mean, you know that. You sue to get some wrongful activity stopped, and 40 years later, you get some opinion from a court that it's completely water under the bridge. That said, I like your description of your method, and it does. This is to go back to compliment our colleagues at NGO Monitor. I like the method, that is to say, without any rhetorical embellishment, taking the picture of the book, the bookseller, the book, and the publisher's contract, and saying, look at this and look at that. Presenting the evidence in the most straightforward way, I think, is obviously the way to go in all of these kind of quasi-legal battles. I do have to say that that's, as a reader of the NGO Monitor, that is what I think these guys try to do, and do pretty effectively. That is not heavily, every once in a while, there's a little rhetorical embellishment, but not heavily rhetorically embellished. They just try to present the evidence, and I think that is why, at least in some contexts, the Israel Fund, for example, because I think that they do have donors in good faith. They don't have anti-Israel donors, they have donors who are in good faith, but just the organization's just overreaching more than their donors think. You present the evidence in a straightforward way, it can be very effective.
Also, I just add some combating boycotts in England and France have been very successful proceeding under anti-discrimination laws. So I don't know if Germany has those, I believe they do, but that may be.
Could I just point information? We did a report of 37 invasions of supermarkets in France in this past year, many of which identified on neo-Nazi sites as Jewish-owned. What happens is, wearing uniform, these BDS groups burst in, go to the kosher stands, rifle everything which is kosher, put them in the trolleys, take them outside, they force their way through the cash desks, and burn them. And so, on grounds of what you just suggested, the Minister of the Interior has now agreed that under an 1881 French law, this is, because it's kosher and not everything that has an affinity with Israel, this is in fact a racial discrimination and can be prosecuted accordingly. So we're looking forward to seeing that happen.
I have a question with regard to the boycott of Israeli goods in Washington State, where the owners of the farmers markets, I believe they are, or the managers of the farmers markets, have explicitly made anti-Semitic, not just anti-Israel statements, but anti-Semitic statements in their justification of why they're doing it. My question is, what's being done about prosecuting somebody like that?
I don't know, I know about the incident you're talking about. I don't know if anyone's tried legal action yet to reverse the decision of that food co-op. There are anti-boycott statutes in the US that people really haven't been exploring to use as a strategy to defeat BDS here, which I think they should start doing. In Davis, California, there was a food co-op that rejected the boycott effort specifically on the basis of those laws. So I think that could be a very effective strategy for people. But in terms of the Washington state, I don't know what legal steps people are taking to
What was shocking and surprising was that the director, or whatever the title of the whoever runs that market, explained it on anti-Semitic grounds that Jews don't have a right to be there, and they use the claim of right of return when they don't have a right to be there in the first place. Now, for somebody to go out on a limb like that, in a commercial enterprise, and makes a statement like that, I mean, he could be sued up and down for everything under the sun. Now, who would be responsible to do that?
Anybody can, I guess. You go for the effort.
And I just have a question, as an interesting from the point of view of how the whole thing began. The metastasization of warfare effectively speaks to when Israel's in the docket. In this instance, the name of being done with act of appointment in the case. It's act of appointment. So the Lawfare thing comes in, as you put it, in terms of the Goldstone atmospherics in the judicial decision. My question is there some kind of Lawfare in the initial deregistration of the name of individual, which then caused them to have to take the action? I mean, was there any sense of arbitrariness or singling out that brought this whole thing about?
You know, it's a good question. It's not easy because we don't know what prompts. We don't know what prompts revenue investigations of an entity. You probably know this. Over the past decade in Canada, there have been revenue investigations of Jewish organizations all over the place. What's prompting this? What is it that's prompting this is not easy to say. There's all kinds of theories out there. I don't like to sound like a paranoid, but there theories are that because Muslim charities since 9/11 have been under scrutiny, there's a kind of lobbying campaign to get the Department of Revenue to also scrutinize Jewish organizations. And you know, sometimes government bureaucracies are sort of prone to this sort of false even-handedness. Hard to know, but I think you're right that as Lawfare isn't a brand new phenomenon. We only started talking about it recently, but it's been it's been around for a while. It's certainly been around since the 90s, if not before. And it often doesn't start in the courts. It often starts with some kind of government investigation, which then prompts. This is a very good example, which then prompts the judicial action rather than starting with court action. I'll also say that Lawfare isn't, of course, only against Israel and Jewish interests. It's also carried on by Israel and Jewish interests. I would call most of the terror victims litigation that's going on, especially in the United States, and then attempts to enforce those judgments around the world, is a kind of a lawfare, it's a lawfare backlash. And we see this going on more and more, I should say, parallel with the Quebec court's dismissal of the Bulleen Village claim against the construction company has been the Quebec court's dismissal of a terror victims claim against a bank, there's the so-called Lebanese Canadian bank, which the U.S. Department of the Treasury has identified as being a primary funder of Hezbollah, or a primary channel for the funding of Hezbollah in Lebanon. There's a terror victims group that brought in, also in the Quebec Superior Court, a claim against that bank for having funded Hezbollah during the summer 2006 war. There's a group of plaintiffs who are Canadian residents with homes that were destroyed in the north of Israel during the course of that war. They brought a case in the Quebec Superior Court. That's also been dismissed on the same theory, that there's no real and substantial connection to Quebec itself, because whatever else the Department of Treasury in the United States says about the Lebanese Canadian bank, it doesn't say that it's doing its funding of Hezbollah through its Canadian branches. It's got 13 branches, that bank has 13 branches in Lebanon itself, and those are the branches that the Department of Treasury has identified as being the culprits, and so there wasn't enough of a connection to Quebec jurisdiction to sustain the case. But it's just an example that the cases are initiated by both sides, sometimes by pro-Israel, by the pro-Israel side, sometimes by the anti-Israel side, and it's become a kind of a multifaceted and complicated phenomenon. I'm hungry for lunch.